Welcome to this video on the harsh reality of immigration detainment when immediate deportation looms. We will explain what typically happens after detention by Immigration and Customs Enforcement, why the process is high stakes for those with 2 or more years of undocumented presence, and what urgent steps may help. We will also cover the role of an attorney, bond eligibility, the asylum 1-year deadline, and realistic odds. Next, we will outline today's agenda so you know what to expect. In this session, we will first present a clear disclaimer and define the scope. Then we will map what typically happens after an ICE detention, explain how entry method affects bond eligibility, explore the asylum 1-year deadline, and discuss realistic odds and limited relief pathways. After that, we will provide immediate action steps, include 2 short quizzes, and finish with resources and a concise summary. Next, let's begin with an important disclaimer. This content is for general informational purposes only and is not legal advice. Immigration law and enforcement policies can change rapidly, and outcomes depend on specific facts. If you or a family member is detained, contact a licensed immigration attorney as soon as possible to get individualized advice. Next, we will explain what typically happens in the first phase after an ICE detention. The first phase begins with detention by ICE, often through an arrest or pickup. Typically, ICE serves a notice to appear, called an NTA, which initiates removal proceedings. It is essential to contact an experienced immigration attorney immediately. They can evaluate the case facts, including the manner of entry, and discuss potential options. If the person is legally eligible, the attorney may request a bond hearing, although bond is not guaranteed. The case is then set before an immigration judge for procedural hearings and, eventually, a final decision that may result in removal or some form of relief. Next, we will explore how the method of entry directly affects bond eligibility. Bond eligibility often turns on the method of entry. If the person entered without inspection, or EWI, current enforcement priorities and statutes make bond eligibility extremely limited. In many EWI cases, individuals remain detained until a final removal order is issued. By contrast, someone who entered legally on a visa and then overstayed may have a chance at bond if they can show strong mitigating factors such as community ties, a stable sponsor, evidence of rehabilitation, and immediate U.S. citizen relatives. Judges consider flight risk, potential danger to the community, and the plausibility of relief before deciding. Next, we will examine the asylum 1-year filing deadline and why it is often a decisive barrier. This comparison highlights 2 common scenarios. For individuals who entered without inspection, bond is generally extremely unlikely, and relief options are limited unless specific exceptions apply. In many such cases, detention continues until the final order is executed. For those who entered lawfully and overstayed, bond may be possible but remains discretionary. The likelihood improves with strong community ties, a reliable sponsor, lack of criminal history, and evidence of potential relief. Next, we turn to the asylum 1-year rule, which often forecloses asylum for those with lengthy, unlawful presence. United States law requires that asylum applications be filed within 1 year of an applicant's arrival in the country. While there are exceptions for changed country conditions or extraordinary circumstances, they are narrowly construed and can be difficult to prove. For people detained after 2 or more years of unlawful presence, the 1-year deadline is typically missed, making asylum generally unavailable and accelerating removal timelines. Next, we will discuss the overall odds and what pathways, if any, may remain. This diagram visualizes probable outcomes based on typical scenarios described. A high likelihood of a removal order around the 90% range, and a smaller slice representing potential relief or release. The actual percentages vary by jurisdiction, facts, criminal history, family ties, and evolving policy, but the key takeaway is that the odds are generally stacked against detainees with lengthy unlawful presence, unless a strong, fact-specific relief avenue exists. Next, we will outline immediate steps that families and detainees can take to protect their position. Act quickly. First, identify the A number and the detention location. Immediately contact a licensed immigration attorney and provide details about the detention, the manner of entry, and any prior encounters with immigration. Begin gathering documentation, such as identification, previous visas, marriage and birth certificates, any criminal records, and prior immigration filings. Identify a reliable sponsor, and assemble proof of community ties and stability. If the person is eligible for bond, Prepare an evidence packet to support it. Pay attention to asylum timelines, but also explore alternatives like withholding of removal, protection under the Convention Against Torture, or immediate relative petitions where feasible. Do not make statements or sign documents without counsel if you do not fully understand them. Next, we will provide a practical checklist and markdown format to help organize these tasks. Use this checklist to stay organized. Record the A number, full name, location, and ICE officer contact. Secure qualified legal counsel and confirm credentials. Collect evidence of address, employment, letters of support, medical or school records, and church or community affiliations. Build a complete sponsor packet showing identification, lawful status, residence, employment, and a clear statement of willingness to host. Track all hearing dates, assemble exhibits, and request an interpreter if needed. Conduct a relief scan focused on immediate relative options, withholding or CAT, and any prior lawful entries that might help. Finally, keep a list of medications, know facility procedures, and identify mental health resources. Next, we will test your understanding with a quick quiz. Quiz time. Question: by when must an asylum application generally be filed after arriving in the United States? Options are A, within 6 months, B, within 1 year, C, within 2 years, and D, there is no deadline. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B, within 1 year. United States law imposes a strict 1-year filing deadline for asylum applications, with narrow exceptions for changed conditions or extraordinary circumstances. Next, let us try one more question on bond eligibility and entry method. Second quiz question: if someone entered without inspection and is detained, how likely is bond under current priorities? Options are A, very likely, B, guaranteed, C, extremely unlikely, and D, automatic with a sponsor. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C, extremely unlikely. Under current enforcement priorities and legal constraints, individuals who entered without inspection are generally not granted bond, and many remain detained until a final removal order. Next, we will present a quick reference table of common relief options and considerations. This table summarizes common avenues: asylum, withholding of removal, protection under the Convention Against Torture, family-based petitions for immediate relatives, and bond. Asylum requires filing within 1 year, or fitting a narrow exception. Late filings are challenging. Withholding requires showing a greater than 50% chance of persecution and does not lead to permanent status. CAT requires proving that torture is more likely than not, and also provides protection without status. Family petitions from a United States citizen spouse, adult child, or parent can sometimes open pathways, but detained processing is complicated and may involve inadmissibility waivers. Bond is discretionary and usually requires lawful entry and strong equities. Entry without inspection generally forecloses bond. Next, we will reinforce the main takeaways as key points. The key points are as follows. First, consult an experienced immigration attorney immediately. Second, the method of entry has a decisive impact on bond eligibility, with entry without inspection generally resulting in no bond. Third, asylum has a strict 1-year filing deadline, and late filings are rarely excused. Fourth, absent a strong and specific relief pathway, the odds of removal are high. Finally, early organization of documents and a sponsor packet improves preparedness for any hearings or requests. Next, we will conclude with a concise summary and resources. For resources, consider calling state or local bar associations for attorney referrals, exploring nonprofit immigration legal service providers, contacting your home country's consulate for documentation assistance, and speaking with the detention facility's information desk about procedures, visitation, and records. The diagram illustrates the connections from the detained individual or family to attorney referrals, nonprofit services, consular help for emergency documents, and facility information. Next, we will summarize everything we covered today. In summary, ICE detention moves quickly, so immediate action is crucial. Retaining a qualified immigration attorney is essential, but it does not guarantee release or success. Entry without inspection usually blocks bond, while some visa overstay cases may have a limited chance. For those detained after more than 2 years of unlawful presence, asylum is often unavailable due to the 1-year rule. Prepare documentation and a sponsor packet early. Given the generally tough odds, concentrate on realistic, fact-specific avenues for relief. Next, we will wrap up with a thank you and a call to action. Thank you for watching. If this video was helpful, please like, share, and subscribe, and share your questions or experiences in the comments. Your feedback can help others who are going through similar situations.